message with no body. And then after that, there's an incoming message with an attachment. It appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment to see if it will come up. It's one of those that will not come up, so go ahead.
the next after that appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues where actually Christina loved an image, then liked the message, it's 10 a.m. by the way, and then added, ha, oh man, okay, thanks for the heads up. He responded by liking that, and then added, set up here if easier for you. And she responded, that's okay, I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone. He responds, LOL, you can. She liked LOL, you can, and then added quick and easy LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added, so nice to experience quick and easy, finally, LOL. Then adds, smeshing good. Then adds, PS, you looked great for just rolling out a couch, LOL, and added an emoji. He added, I'm working on brief, head over soon as get to stopping point like 1. She responds with the action of loving the previous message, or one of the previous messages, so nice to experience quick and easy. Laughed at also the PJ, the PS, looking great comment. And then added, ha, thanks, figured I should put a clean shirt on even if I had PJs on, the bottom half, LOL. She adds, and okay, just let me know as you're finishing up. He adds, just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall, price about the same. U-Haul, more flexibility, like taking things straight to storage. She responds, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and cats will go in the Jeep and I'll drive with Emerson in my car. She added, LOL, the Beverly Hill. He added, LOL, the Beverly Hillbillies, coming from dem slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added, headed over shortly, brain approaching short circuit. She added, ha, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up. He added, he liked the previous message, and then there was a outgoing phone call to Doug for 38 seconds. Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night, with an emoji.
Okay. So the liked headed that way was at what time?
That was at 2 o'clock in the afternoon.
And then the good night was at what time?
It's 8:27
Okay.
at night. Saw 2 of them, apologize.
And then after the good night?
After good night, there's an outgoing, indeed, LOL, good night, from Ashley. And then after that, there's a an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
And the next entry?
Appears to be another attachment roughly 15 minutes later.
Okay. And if you could read what this says?
Live a life filled with love. Another Bible verse, Ephesians 5:2. At 9:26, there's a message from Doug. It says, "Good morning." Minute later, there's an action of loving an image. Second, loving an image. And he responds with, "Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
Chai. At 9:27, there's a response from Christina, says, "Good morning." There's a repeated response, previous message, "Dr. Q is at 10:30, do you want a chai?" And then bagel, he added to it. She responds, "Ha, that's okay, thank you. If I do that this early in the day, I'll be done for the day, LOL, but thank you." He added, he liked that message. And then the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open. And then the next entry.
It's at 10:35 a.m. From Doug, are you able to make Dr. Q okay? She responds, "Yes, LOL, be in a minute." He responds, "No rush, he's still not out, LOL." She responds, "I know, LOL, waiting for mom to come out so we can swap." There's a message without just a rectangular square there. And then after that, there's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now, the LOL was at 10:42 a.m., and then what's the next entry?
correct. 10:42 a.m. was the LOL. And then the next is at 5:39 p.m., which is a phone call from Doug, and with 0 seconds. Then adds after the phone call, "I be here," and then another phone call for 15 seconds at 5:40 p.m. Then,
Your Honor, not to tax Sergeant Keelis because he's been reading for a while, but it's a little tough to follow. I wonder if he could give us the number of the message, so it would be much easier to follow.
that's fair.
And I don't know why, but I think your numbers may be off. You're,
Okay.
All different from this?
they might be. Can you look?
IB here is, well, we're not using the numbers that are built into Excel. I want to say
Okay.
the
That's
numbers
what it
are
is.
an actual column. So technically IB
Hang on, I'll
here,
move this over. That's what you're looking at.
correct, IB
Okay.
here would be 212.
If he gives you that number, are you okay with that?
Can you show him?
Like on yours, 214. Where's 214? These numbers here match what he's saying. There's numbers on the Excel spreadsheet that are showing, and that's what was confusing me. But the numbers he's saying are the numbers on the sheet.
Okay, so we're on.
We're
right
on
now,
215, correct?
Correct,
Okay.
Okay, so if you, Sergeant, if you could just call the number out.
sure, not a problem.
Thank you. Thanks, Judge.
Of course.
So we left off of 215, which is at 9 o'clock. It's a good night with an emoji. 216 is an attachment, a JPEG. and that was at 6:43 a.m.
And that is on the next day, correct?
Correct.
9/26.
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
And then you can continue from there.
All right, so moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds with also with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log with from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message, and it repeats. 224, want to come pick me up, and we can go get the truck.
And that's from Ashley.
And that's
correct?
from Ashley.
Okay.
And Doug responds, sure, with 225, sure, headed that way. 226, I be here. And that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening, and it's from Doug, and it's a good night, sweet dreams. Then at 228, 9:23, Ashley responds with the action of loving the previous message, and also responds with a good night. 2:30, there's another attachment at 6:42 from Doug to Ashley.
I'll pull up the attachment. What is that?
It's the Bible verse. After the attachment at 2:31, Doug sends good morning. 2:32, she responds, loved an image. And 2:33 with a good morning. 2:34, he responds with looks like a strong fist up emoji. And 2:35, there's also an incoming from Doug with just a little rectangle. 2:36, she responds with LOL. 2:37, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 2:38, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 2:39, how's it going over there? Making progress? He responds at 2:40, number 240, at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, aka bed. Pretty much emptied. Taking solely to get his shots, then to doggy spa to get groomed and stay until ready to go. 2:41, he adds, I'll come there after drop him off at 3. .242, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds, 244 adds, great, could you run by Lowe's before you come over, grab a few large and mediums. 245, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure I need a few, but just a repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bit here. 248 from Doug, he likes the previous message and adds, and 249, okay, let me know anything else if think of. 250, she responds, tape. 251, and also adds LOL. 252, he responds, ha, K. 253, just finished vet, headed to spa, LOL. 254, she laughed at that previous message. 255, He says, headed there. 2:56. She responds, okay. The next line, 2:57, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon,
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two?
Correct.
Okay, so after, okay, 1 minute, what is said?
Then 2:59, about to head back from Doug. And then the message after that appears to be an attachment at 5:11 in the afternoon.
And I'm clicking on the attachment for the record.
Yeah, appears to be,
Oh, go ahead, I'm
it
sorry.
appears to be maybe the U-Haul truck that they're loading up.
Okay. And that was sent from Doug?
That was 5:11, yeah, that was incoming, yes, from Doug to Ashley.
Okay, and then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 PM, was that the last communication between these two?
I believe so, yes.
Okay. Thank you. Judge, can we approach just a moment?
Yes.
Before.
Members of the jury, there's one legal issue that I need to resolve before we finish up with this witness's direct. So I'm gonna excuse you in the back. It should take about 10 minutes. It's my best guess. So please don't begin deliberations amongst yourself. You can communicate outside, send and receive texts, emails, telephone calls, but just don't talk about the case. And don't do any research on the people, places, things, or legal topics you've heard anything about. And I'll get you back out here as soon as I can. All right, you all can have a seat. Detective, I don't know to what extent we're gonna be talking about the testimony you may have, so I'm gonna go ahead and excuse you for right now, just
Sure.
to be cautious. Please understand the rules of sequestration, the rule of sequestration has been invoked. You're not to discuss your testimony or the answers you've given or the questions you've been asked with anybody outside this room. You're not supposed to talk with any other witnesses about the testimony they've given or the questions they've been asked. And to my understanding, this may be online, you're not to watch or view anything related to this case until you're released from your subpoena or the jury's returned a verdict in their discharge.
Understood.
All right, so just step outside and get you back in as soon as we can. No, I think it's fine, because I think they're still gonna need them down. I can see all right. Okay, the detective is out of the room. We can have argument on this video.
Thank you, Judge. And thank you for rehearing the issue. I had a chance to research it. We obviously weren't.
If you've got case law,
Well, I
contrary to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thank you, sir. I actually just sent one to the printer because I didn't know if you'd rather have it, but it's called, Lumarque. I don't know, Lumarque. It's 44 Southern Southern 3rd, 171.
Say that again.
Sure, 44 Southern 3rd, 171. There's a yellow flag, but it's for a different reason. This case was,
Sorry. Judge, are you looking it up electronically, or would you like a hard copy?
No,
okay.
I'll take a copy if you have one.
Oh,
Give me 1 second, Judge, sorry.
Oh, that's all right.
It would only
Is
let
that the
me
only
print-
one you've got? No,
would
you
only
can
let
have
me
it.
print one at a time. I can do it, Judge.
we printed this for you, but then realized we needed 2 copies, so here's the paper copy.
It's coming off the printer.
Judge, they revoked my copy in favor of the court.
In favor of the court's.
We're not going to do anything until you get a copy.
It should come any second.
Of course, I can't blame their decision, Your Honor.
All right, go ahead.
The part that I'm referring to is on the second page. It's a short case, luckily, where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law. That's my understanding and my feeling, but that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third DCA here said the court erred. The images and text messages were found on the defendant's cellular phone.
Can you-
seized
Can you slow down just a little bit for the court
Sorry,
reporter?
Judge, I apologize. The images and text messages were found on the defendant's cellular phone, seized pursuant to a search of the defendant's home through a warrant shortly after the alleged incident. This fact was testified by the state's forensic expert and is sufficient to authenticate the exhibits. Here, those phones have been in evidence since the day before. The contents of them were admitted with a trial exhibit today, and not objected to. The only thing is this one video was objected to, this attachment. And the state would argue, based on this case, that we have established this phone was properly searched, properly downloaded, and the material was found on the defendant's phone, the video found on the defendant's phone, and therefore the state would argue it should be admitted.
All right. Mr. Taylor?
Just 1 second, Your Honor. Okay, I distinguish it on 2 bases, Your Honor. They quote U.S. versus Caldwell, 11th Circuit decision, holding that authentication of evidence merely requires a finding that the evidence is what it purports to be. Well, that's the exact issue, Judge. Sergeant Keyless cannot do that. He can only say this is a video, it was on the phone. He can't say it's a true and accurate reproduction of what took place on that morning. He doesn't know, for example, who was there that might not have appeared in the video, what the motivation was that brought them there. He wouldn't be able to say whether it was under coercive circumstances. I don't think he qualifies to be able to lay that predicate. And the second reason why I don't think this case is applicable is, in this case, they held that it was admissible because it constitutes evidence of motive. Judge, this is a second-degree murder case. As the court knows, motive in second-degree murder is not an element. There is no obligation that murder be proven. I don't think they can lay the necessary predicate for it.
State rebuttal.
Just that I think defense counsel's arguments go to the weight, not the admissibility. I think this case stands for the fact that we've entered, without objection, cell phones that contain this video, and then now without objection, the trial exhibit with the attachments and the CD. The objection was just to one after, which I think is also an issue, but I think we don't have to get there. But I think this case stands for the fact that once we've laid the predicate, that this was a properly searched phone, and that the data on it was properly removed, and the detective testified that everything was in order, then we've laid the predicate for the contents of the attachments to also be admissible based on this case that I can't say the first name of.
What was the date and time of this particular message?
The message was, I don't know that you can read the small print on that, but there's a copy, but it is, if you're wondering if it was before the Panera conversation or after,
I want to know the day and time that this attachment was sent.
it was sent 9/20 of 2020 at 6:40 PM.
What number are you referring to?
Oh, 25.
And the Excel spreadsheet, which is the data dump from the defendant's cell phone, shows it's in blue. So it's
From the
from,
defendant's phone. So it's from the defendant's phone to, I'm sorry, from.
Correct.
the
It's
victim's
from-
phone to the defendant's phone.
right, it's from Doug Benefield's phone
Yes.
to Ashley Benefield's phone.
Yes.
sufficient evidence at this stage. Certainly, they met the admissibility that these exhibits constitute evidence of motive. As we've discussed, motive is not an element. But the state has made the argument in the past and makes today that the entry of these items is not for the truth of the matter asserted, but to show the relationship and interactions between the parties in the days leading up to the homicide and the normal texts and banter and communication of a married couple that is in the middle of a divorce. So for those reasons, I will reverse my prior decision, and the video would be admissible under this case.
Thank you.
So we did that specifically so you could finish with your direct,
Yes.
and the ruling is made, so then it's available on cross. I know we talked about different options, but I'm glad we did it that way because I think it makes a lot more sense.
So we can recall him and play it, and then we'll tender the witness.
Correct. So when the jury left, he was on the stand.
Oh, I'm sorry.
Right, so I'm just gonna put him back on the stand. The jury won't know any different.
Yes, sir.
All right, so if we could bring,
Can we take a quick restroom break?
all right, 5 minutes?
Just 5
Sure.
minutes.
Okay,
Thank you, Judge.
All right, can I go ahead and bring Detective Keelis back in?
Yes, thank you.
All right, Detective, if you can retake the stand, reposition yourself as needed. Sir, did you speak with anyone about your testimony or their testimony or anything at all?
No.
Ready to bring the jury back in?
Yes.
Mr. Taylor?
Yeah, sorry.
Bring them in. All right, y'all can sit down. Welcome back, everybody. Anybody begin deliberations, communicate with anyone outside the jury about the case, or do any research on the case?
No, sir.
All right, everybody says no. State, you can resume your questioning.
Okay, I just have one thing before I turn witness over. There was an attachment, a video that was sent by Doug, it's line 25, so sent by Doug to Ashley, correct?
Here, hold on.
Oh, you don't have the sheet in front of you.
No.
Sorry.
Thank you, thank you. Line 25 is an attachment from Doug to Ashley Christina.
Okay, I'm gonna play that attachment at this time.
I don't even know what it's doing. I think it's giving you clues that I gotta guess.
Is it like with words? I'd say not safe.
Get real?
Second part.
Real?
Working mother. Not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum.
people generally prefer like grades.
Oh no, it's running out of time.
I live in
House.
a
Real house. Wife.
So put together.
Housewives of.
Real housewife.
Oh, real. Oh.
Okay, thank you, I have no further questions.
Cross, and Mr. Taylor, do you want the screen, or do you want the lights back up?
I'm gonna use the screen.
Yes, sir, we'll leave it as is.
Do you want your, oh, you're getting, okay.
Good morning, Sergeant Keeler.
Good morning.
I want to make sure that we can establish the contours of your testimony. From the Technical Services Unit, you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the messages, you just are able to read what's printed.
I can read what's printed from the extraction, yes.
Right. But, for example, there were quite a few Bible verses. You wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I can tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass to you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
I would object to be on the scope.
Okay, I don't know.
Come here, Brett.
Not yet.
I'm going to pass to you Sergeant Keyless what I've marked now as Defendant's Exhibit 3. Those would be, would they not, text messages that you also extracted?
I believe these were the text messages that
We
you may
requested.
highlighted during a deposition, and
Yeah,
we
and that-
confirmed that these came from, I believe, Doug's phone.
Correct.
Yes.
And that we requested
I apologize, Judge. I do think we need to approach it now.
All right, members of the jury, this is gonna take a little bit longer, so what I'm gonna do at this point is, it's about 11:30. I'm gonna let you go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45. That gives you a little bit extra time. That'll give us time to take care of what we need to take care of. And we'll get you back up here as soon as we can, right after your lunch break. Please remember, don't discuss the case amongst yourselves. Don't discuss the case with anybody else. And don't do any research on the people, places, things, or legal topics you've heard anything about. All right, thank you. All right, you go ahead and bring up the lights. Okay, Detective Keelis, we're gonna let you go also for lunch. Just remember the admonitions from earlier, don't discuss the case with anyone, don't let anyone discuss the case with you. Don't talk with any other witnesses, you can't talk with the attorneys about your testimony, don't do any research or watch anything online.
Understood.
If you could be back here at 12:45.
Sure.
All right, thank you, sir. Okay, we'll see you back here at 12:45.
You will see pictures of those knives. You will see pictures of the house and where those items were located when the police were at the house that particular night. You will hear from a medical examiner in this case more about that fatal chest wound and what the details of that wound, how deep it was, what kind of injury it caused, what damage it did to Michael's body, and what resulted in his death. We ask, ladies and gentlemen, that you listen carefully to the evidence and keep an open mind. And that's something you're going to hear us say, you'll hear the judge say, you'll hear everyone say it again and again throughout the course of this trial, but it is paramount in this type of a case that you listen carefully and keep an open mind. And that you not forget that you, as a group, bring to this case your common sense and life experience when you evaluate the evidence. And we ask that you do that as you continue to listen to the evidence in this case. And the evidence will tell you what happened in the Ritchie household that night on January 28th, 2021. At the end of this case, we will return and ask that you find the defendant guilty of murder and assault and battery with a dangerous weapon, because the evidence will prove to you beyond a reasonable doubt that she is, in fact, guilty of those crimes.
Thank you. Next, we'll hear from the defense. Attorney Wood.
Christine Ritchie never intended to kill Michael Ritchie on January 28, 2021, and the Commonwealth doesn't have any evidence to prove that she did. The argument that occurred that was just described to you, the confrontation that was just described to you, all of that information all happened during about a 15-minute pocket between 4:30 and 4:45 on January 28th, 2021. And every answer to every question that we have about Christine's intent, Michael's intent, Michael's last actions and Christine's actions are contained and sealed in that 15-minute pocket. And ladies and gentlemen, that's probably why the Commonwealth is going to spend such a small amount of time talking about that 15-minute period, because they want to distract you. Christine's words are really the only evidence that we have of what occurred during that 15-minute pocket. And those words, remember, were spoken in the moments after all of these events happened. It's true that she doesn't give a complete statement of everything that occurs, and as we go through the evidence in this case, and when I come back and talk to you at the end, I'm going to suggest to you, through reference to both the forensic evidence as well as putting together the statements, about what probably happened around and between the details of what it was that she said. When the police arrive, the evidence is going to be that Christine Ritchie is absolutely beside herself. Absolutely beside herself. She is crying, she is heaving, she is hyperventilating. The first responders come to the scene and she can get almost nothing out. She says he collapsed, that comes out. The Commonwealth wants it to be the case that that means that she told some sort of misleading statement. The evidence is going to show that she gave an incomplete statement and that maybe she wasn't in a position where she even could give a complete statement. She was just too upset. After Michael Ritchie's body is removed from the house out to the ambulance, there's going to be evidence from an officer by the name of Chris Martin, who's going to say that at that point they sat her in a chair and they asked her what happened. While the body is still out at the ambulance, while they're so-called discovering the stab wound that you just heard a moment ago. And the evidence is going to say that when she's confronted at that moment about what happened, she gives a little bit more detail, but she's still extremely upset. She's so upset, in fact, that she actually takes some medication to try to calm her down. But as she begins to say the details of the case, she mentions the knife, and she mentions the argument and the fact that it escalated. And that's going to be supported by the testimony of Sophia Ritchie, who heard that escalation of the argument into a screaming match. And it's true, she does say, I held the knife out, and then at another point she does say, he lunged at me. And at another point mentions being attacked. And I'm going to suggest to you that the evidence will be that even when Christine said those words, that wasn't everything that happened. And at that point, the evidence will show she may not have had a complete memory of what had just fully occurred. But Christine Ritchie's words are the only direct evidence that you're going to have about what happened between 4:30 and 4:45 p.m. on January 28, 2021. They're the only eyewitness reports of what happened. And they don't at all support the story that the government just told you. And that is probably why they are going to spend the entire case discussing things that didn't occur during that period of time. I expect that they are going to parade a bunch of witnesses in, remote friends of Michael Sr., who are going to be allowed to offer their opinions about the defendant, that they are going to pick along a 2.5-year period, a series of isolated events, and try to string them together to create the most damning possible picture of who Christine Ritchie is. And that they will do so because they hope that you will be so distracted by the question of whether Christine Ritchie is the type of person that would commit this crime, that you'll forget that the real question is whether she actually did it. As I say, at the end of this case, we will hear forensic evidence. We will come back and we will tell you a little bit more about what happened in January 28, 2021 in the absolutely critical 15-minute period. Talk about the mechanics and what's suggested. And a lot of it will be inference by inference, because we won't have that type of eyewitness testimony beyond someone's statements that was very, very affected by what had just happened to them. But what emerges from that is a very, very different picture altogether. Now, the Commonwealth wants you to tell you these stories about the past and about the affair. And it's true, there's going to be a story about an affair, and it's going to be a big part of the Commonwealth's case. This was an affair that took place in 2018. And a lot of the events that they're going to talk to you about physical confrontations, happened within just a couple of months of that event, maybe anywhere from a 6-month to 9-month period after that event. You're going to hear about other events that happened in the subsequent year and a half. Things like Michael going to AA, Christine supporting him in going to AA, him getting sober, him getting counseling, Ms. Ritchie getting separate counseling, them going to couples counseling, them reaffirming their vows in Hawaii in 2019. And you're going to hear from all of the children, and although they're going to say that there was fighting still and there was a fair amount of marital discord, they're not going to describe the type of events that were occurring in 2018. But the Commonwealth wants to sort of string these things together from 2.5 years earlier to try to pretend that that says something about Christine Ritchie in 2021. I'm going to ask you not to be distracted, to focus like a laser on the relevant period of 4:30 to 4:45 on January 28th, 2021. And I want you to be extra vigilant every single time the Commonwealth tries to distract you and talk to you about ancient history and tries to tell you about who Christine is and why you should believe bad things about her, and focus on what do they actually know about what happened on January 28th, 2021 between the hours of 4:30 and 4:45. And if at the end of the day, what you're left with is, I just don't know what happened, which is exactly where they are, then I'm going to ask you to find Ms. Ritchie at the end of this case during closing not guilty.
Thank you. I'll seek counsel at the side of the bench. So jurors, we've now heard the opening statements, and I'm going to move this out of the way so I have a clear sight view. We're going to move to the evidence in the case. The Commonwealth may call its first witness.
Thank you. The Commonwealth calls Sophia Ricci, please.
I want you to follow that officer right there.
Good morning. Do you solemnly swear that the testimony and the evidence that you shall give to the court and the jury in the matter now pending between the Commonwealth and the defendant, the bar, shall be the truth, the whole truth, nothing but the truth, so help you God? Thank you. You may have a seat.
Thank you, Chairman.
You may proceed.
Thank you, Your Honor. Good morning. In a loud, clear voice, can you please tell us your name and spell both your first name and your last name?
Sophia Ricci, SOPHIYARICCI.
Thank you. And Sophia, what is your date of birth?
05/22/04.
How old are you?
I'm 20 years old.
Okay. And where do you currently live?
I live at my house, 679 Moraine Street.
How long have you lived at that home?
Since I was 3.
And where did you live prior to that, if you know?
Rosendale.
And who do you currently live at that location with?
My brother, Angel.
And how old is Angel?
Angel is 27.
And do you work?
Yes, I do.
Could you tell us a little bit about what you do, Sophia?
I work at a dog kennel.
And so what kinds of responsibilities do you have there?
So I basically take the dogs in, out, clean up their messes, clean up bowls, basically clean and hang out with dogs.
And do you like your job?
Oh, I love it.
And were you a dog lover before starting that
Yes.
job? Okay. And do you have any pets of your own?
Yes, I have 2 cats.
Did you used to have any other animals?
Yeah, I had 2 dogs.
Okay. And do you work full-time at the dog kennel?
Part-time.
And do you do anything else besides that?
No.
And did you graduate high school?
Yes.
What high school did you graduate from?
Ashland High School.
And had you always gone to Ashland High School, or did you start high school somewhere else?
I started high school in Marshfield.
Okay. And you successfully graduated, though, correct?
Yes, I did.
Okay. And did you start working at the kennel soon after you graduated?
Yes.
And where is that kennel?
Marshfield.
Okay. And growing up, Sophia, after you moved to your current home on Marine Street, who did you live at the home with?
I lived with my mom, my dad, and my brother.
And when you say your brother, do you have one brother or more than one brother?
I have 2 brothers.
And could you tell us their names and their ages?
Michael Ritchie, he is 25, and then Andrew Ritchie, he is 27.
And when you say Michael Ritchie, is he a junior?
Yes.
Okay.
Yes.
And who is Michael Ritchie Jr.'s father?
My dad.
And he has the same name?
Yes.
Michael Ritchie?
Yes.
Okay. And then what about Angel, your brother Angel, who is Michael Ritchie his father as well?
No.
Did he adopt him at some point?
Yeah.
So did Angel call him dad?
Yes.
And was he raised as Michael's son?
Yes.
Okay. And did you grow up with both of your parents in your home on Marine Street?
Yes.
And what's your mom's name?
Christine Ritchie.
And do you see her here today?
No.
Do you want to stand up?
Oh, yes, I do.
Okay. Could you just point to her and tell me something she's wearing?
She's wearing a pink blazer, I think.
Okay.
And glasses.
May the record reflect the identification by the witness, Your Honor?
The record will so reflect.
Thank you. And what about your father? I think you just indicated his name, just for the record again, his name?
Michael Ritchie.
And that was senior, correct?
Yes.
Okay. And with Her Honor's permission, may I approach the witness?
You may.
Just approaching you with a photograph. I'm just going to ask you to take a look at that photograph and tell me if you recognize what it is.
Yes.
Or who it is.
My dad.
Okay, make sure you speak loudly, okay?
Yes, my father.
Okay. And is this a pretty fair and accurate picture of what he looked like?
Yes.
I'd ask that this be marked as the first exhibit and published, please.
Any objection?
No objection.
It'll be marked and admitted as Exhibit 1 and may be published.
Thank you. Exhibit 1 so marked.
Now the jurors see the electronics.
And this is your father?
Yes.
And did you have, what did you used to call him?
I just called him Dad.
Okay, and did he have any nicknames for you?
It would vary. Honey, sweetheart, sweetie.
Your Honor.
And do you know what your father did for work while you were growing up?
Yes, he was a firefighter.
Where was he a firefighter?
Boston.
And did he have any other jobs that you were aware of?
He was a sprinkler. He installed sprinklers in buildings.
And what was your relationship like with your father growing up, Sophia?
We were very close.
What kinds of things did you guys used to do?
We would go bowling, go to the seawall, watch the waves, play baseball outside, sports, and watch movies and watch TV shows.
Was he around a lot growing up?
Yeah.
And based on your observations, did he have a fairly similar relationship with your brothers?
Yeah. It was obviously different because I was the daughter, but he had a close relationship with my brothers too.
And what was your relationship like with your mom growing up? Was it close as well?
We were very close.
Okay. Sophia, I'm going to draw your attention back to a date of January 28th of 2021. Do you remember where you were during the daytime hours?
I was at school,
And what school was that?
Marshfield High School.
And do you remember what grade you were in?
I was a sophomore.
And was this during COVID times?
No, this was before COVID.
Okay. And do you recall what hours you were at school?
I do not recall what hours.
Do you know what roughly time you would get home every day from school?
1:47.
Was that the 1:47 was the bell at school and then you would leave, or 1:47 you'd walk in your home?
1:47, the bell.
Okay. And how would you get home?
The bus.
And approximately how far away is your school from your home?
5 minutes.
It was a quick ride?
Yeah.
Okay. And on this particular day, did you take the bus home?
Yes.
Okay. And before leaving for your school day, anything unusual in the home?
No.
Everything seemed pretty normal to you?
Yeah.
And when you got home, what did you do?
I went up to my room.
And can you describe your home?
So if you walk through the front door, there's a fireplace. I call the fireplace room. And then when you walk up the stairs, there's my room. And then walk down a hallway, there's my brother's room, the bathroom, and my parents' room.
So where was Angel's bedroom?
Angel's bedroom was in the basement.
And so he converted the basement basically into a bedroom?
Yeah.
And then were any bedrooms on the first floor? So the remainder of the bedrooms were upstairs, correct?
Yeah.
And where was your parents' bedroom in relationship to your bedroom?
They were across from my room.
So just right across the hallway?
Yeah.
And what about your brother, Mike? We'll call him Michael Jr.
He was across too.
Okay. Were there any other bedrooms upstairs?
No.
Okay. And when you got home, you indicated you went to your bedroom, is that right?
Yes.
Did you see anybody when you first came in?
I do not remember.
Okay. And do you know if anybody was home?
I think my mom was home.
And do you recall seeing her on the first floor when you walked in?
I do not recall.
Okay. Do you remember speaking to her at all before you went to your room?
I do not remember.
Okay. And may I approach the witness?
You may.
Thank you. I'm just going to ask you to take a look at a photograph and tell me if you recognize what it is.
Yes,
What do you recognize that to be?
that's my house.
And is that a fair and accurate depiction of how it appeared back in 2021?
Yes.
Okay, I'd ask that this be marked as the next exhibit and published as well, please.
Any objection? It'll be marked and admitted as Exhibit 2 and may be published.
Showing you again what was just marked as Commonwealth's Exhibit number 2, Sophia. Just for some perspective, just getting back to your description of where certain things were in the home. With Her Honor's permission, may the witness get up and just point to different areas that she just spoke about?
She may.
Thank you. Sophia, if you can. I don't know if we have a pointer or not, but just with your hand, if you can just show us what we're looking at here in terms of, take us through the front door and tell us where the different rooms that you described are, please.
So, this is the fire room where the fireplace was, and then when you walk up the stairs, this was my room, this was the living room, and these two windows were my parents' room.
And then what about Michael Jr.?
Michael Jr.'s window was on the side.
Okay. And the kitchen, where's that?
It's in the middle of the house.
So when you walk in that red door, is the kitchen ahead of you?
Yes.
Okay, thank you. You could proceed again. And so when you walked in the door, your first memory right now is that you went right to your bedroom. Is that right?
Yes.
Is that typically what you would do when you got home from school?
Yes.
And do you recall if your parents' bedroom door was open or closed?
I do not recall.
Okay. At some point, did you become aware that somebody else arrived home?
I do not remember.
At some point, did you hear voices?
Yes.
And where were those voices coming from?
The living room.
And whose voices were they?
My mom, my dad's.
And what tone of voice were you hearing from your mom?
Can you repeat that?
Sure. Well, I'll ask a different question. That wasn't a good one. I'm sorry. So you were upstairs and you could hear your parents downstairs, is that right?
Yes.
And how loudly were they speaking?
Not too loud.
But loud enough to hear?
Yeah, loud enough so I could hear from upstairs.
Do you have a television in your bedroom?
Yes, I do.
And is it typically on when you go in?
Yes.
So you had the television on this day, is it fair to say?
Yes.
And you heard them downstairs, right?
Yes.
And is it fair to say that their voices were elevated enough that you heard them?
Yes.
Okay. And do you recall hearing yelling?
Yes.
And who did you hear yelling from?
My mom.
And did you hear any words she was saying?
No.
Was this alarming to you, or was this kind of your life?
It wasn't alarming to me.
Was not alarming, and why was that, Sophia?
I was used to it.
Okay. And when you say you were used to it, was that how things had been always, or had they turned into your new normal at some point?
It turned into my new normal. It wasn't always.
So when you were a little girl and up until you were maybe 14 or so, 15, were things not like that in the home?
Yes.
Okay. And were you able to, do you typically get involved when you hear your mom yelling and an argument going on, or do you kind of stay away from it?
Not typically, but there was sometimes I would get involved.
And on this particular occasion, what did you do?
I didn't get involved.
Did you stay in your room?
Yeah, I stayed in my room until I heard my name.
Okay. And in the past, well, let me ask you this. How often would you hear your parents arguing in the 2 years leading up to January 28th of 2021?
Your Honor, objection with regard to foundation. That time frame is a 2-year period.
All right.
2.5.
Is that the foundation?
Were you living in the home in 2019?
Yes, I was.
And during 2019, was there a notable, were your parents arguing more often then?
Yes.
And how often were they arguing in 2019?
I do not recall how often it was.
Was it fairly often?
Yeah, it was fairly often.
And what about in 2020? Were you living in that same home?
Yes, I was.
And was it similar to what you just described as happening, arguing often?
Yes.
And the early 2021 leading up to the day we're talking about, was it the same then as well?
Yes.
And were the arguments typically about one thing in particular?
Not all arguments were one thing.
What do you recall the arguments being about?
I don't recall all of the arguments, but I just remember them being different things. It wasn't just one thing.
Would your mom ask your father questions about something?
Yes.
Objection to the form of these questions. These, I think, need to be open-ended.
Right, I'll rephrase. Thank you. Sophia, what, if anything, would you hear your mom consistently asking your father about?
I do not recall.
Do you recall who, if anyone, would your mother bring up during the course of the arguments?
I do not recall.
May I have one moment, please, Your Honor? Yes. May I have just one moment, please? Yes. Thank you. Sophia, do you remember actually the day of these events that we're here about today on January 28th, 2021? Do you remember being interviewed by the police about what had happened?
Yes, I do.
And is it fair to say that your memory then was probably a little bit better than it is now?
Yes.
Would it refresh your memory to see a transcript of what you said about these arguments?
Yeah. Yes.
May I approach? You may. Page
Can I see
one.
the page?
Yep. Page 115. Sophia, I'm just going to ask you to take a look at a transcript of the interview you had with the Marshfield Police. Specifically for the record, it's page 1-15. I'm going to ask you to read to yourself, so not out loud, lines 12 to 20. Actually, lines 12 to the end of the page. And when you're done reading, take your time, just look up so I know you're done, okay?
Okay.
Thank you. Is your memory refreshed, as we say?
A little bit, yeah.
Okay, so I'll just ask you again, do you remember typically what your parents would argue about?
About the drinking.
And what else?
The affair.
And the drinking, I'm just going to ask you a couple of questions about that. Do you recall how often your father would drink?
Every day.
And what he would drink?
Beers.
And is it fair to say he would not be drinking, as far as you know, while he was a firefighter, right?
Yeah.
When he would come home, would he have a few?
Yes.
Okay. And what kinds of things would you hear your mother saying about the affair when she would be questioning him or asking him?
I don't remember what she would ask about. I just remember like what it was about, but I don't remember what she would ask.
Okay. And is it fair to say that between the drinking and the affair, those were typically what the arguing was about?
Yes.
Okay. And other than I don't want to categorize it as yelling, but other than the loud voices you heard on the date of January 28th, 2021, what, if any, other sounds did you hear downstairs?
I heard movement and banging.
Movement and what?
Banging.
Banging?
Yes.
Okay. Did you know what the banging was?
No, I did not.
Okay. Where did you stay while you heard them? Is it fair to say they were yelling?
Yes.
So where were you during the yelling and the banging?
In my room.
Okay. At some point, did you leave your room, Sophia?
Yes, I did.
And why did you leave your room?
I heard my name being called.
Who called your name?
My mom.
And other than calling your name, did she yell anything else to you at that time?
No, she just called my name for me to come downstairs.
And what did her voice sound like?
She sounded very panicked.
Okay. And did you do as you were told and come downstairs?
Yes, I did.
And when you came downstairs, could you describe what you saw?
My dad was laying down on the floor.
Okay. And when you say he was laying down on the floor, could you describe where he was when you saw him?
Where he was, or
where on the where in the home he was on the floor?
He was in the living room near the dining room table.
And was he laying down on his back or on his front?
His back.
And what, if anything else, did you observe about him as he lay there?
I don't recall.
Do you remember if his eyes were open or closed?
No, I do not.
And were you able to speak to him when he was on the floor?
No.
Okay. Did you see any? What, if any, injuries did you see?
No, I didn't see anything.
Did you see anything in your father's hands as he lay there?
No.
Where was your mom in relationship to where your father was laying on the ground?
She was right next to him.
Was there anything in her hands?
No.
And when you got downstairs, did you have a conversation with your mom about why your father was on the ground?
No.
Did she tell you, aside from a conversation, did she make any statements to you about why he was on the ground?
No.
And what was the very next thing that happened?
She told me to call 911.
And did you do that?
Yes, I did.
And what phone did you use?
I used my phone.
It's like a cell phone?
Yes.
Okay. And how did you even know what to tell 911?
Can you explain that question?
I'll rephrase it. You picked. Did you have to go find it?
I walked down with it.
Okay. And with her honor's permission, may we just very briefly approach? Yes, thank you. I'm going to ask that the disc of the 911 call be marked as an exhibit and played for the jury. Any objection to that?
No, Your Honor.
Be marked and admitted as Exhibit 3, and it may be played. Thank you. Exhibit 3 so marked.
911, the sounds are going with the emergency.
My dad is injured on the ground. I don't know what's happened, but he's been sent an ambulance or something.
Okay, where are you located?
679 Lorraine Street.
Say again?
679 Lorraine Street.
679 Lorraine Street?
Yes.
Okay, is he breathing?
Is he breathing, Mom? He's breathing.
Okay, stay on the line for me. I'm going to transfer to the ambulance, all right?
Okay.
Fire rescue, where's your emergency?
Hi, my dad is on the floor and he's breathing and he can't get up. And can you just please get the ambulance?
What's your address?
679 Lorraine Street.
679 Lorraine Street. How old are you?
16.
Okay, how old is your dad?
My dad is 50.
50. You said he fell?
Yeah, he's on the ground unconscious right now.
Is he breathing?
I don't know if he's breathing, but can you just please send an ambulance?
Okay, stay on the line. I'm going to get him started your way, okay?
Okay, he's breathing, but can you just please come here?
It's 382. Street. Like a 8-year-old male. 679 Range Street. Hello, you still there? Hello, you still there? You with your dad right now?
Yeah, my mom's a little bit.
Did he fall or did he just pass out all of a sudden?
I don't know. I'm just getting downstairs with this whole makeup full.
Okay, and he's not alert, he's not talking?
No, he's completely out.
Okay, and he's not breathing normally?
No.
Okay. Do you know CPR?
I don't know that.
Okay, he's on the floor though right now? He's not on his bed or anything? Okay, you said your mom's there? Can I?
No, she's okay now.
Okay, because they're on the way, but I can give you instructions for CPR to help them, okay? They're on their way, but I can give you instructions to help them, okay? Martha Clark on the traffic, engine 3, head to 679 Range Street, on medical, still on 15. Is he on his back?
Yeah, no, he's on his side.
Okay. Can you have your mom roll him onto his side?
He's already on his side.
Or on his back?
No, oh yeah. Mom, roll him on his back. On his back.
Is he on his back now?
Yeah, he's on his back.
Your mom, they're on their way. I'm gonna give you instructions to start CPR, okay? Okay. Are you with me?
Yes, and my mom's trying to get her phone.
Where'd your mom go?
My mom said to get her phone.
Are you with your mom right now?
No, she's downstairs, but my dad has a lot of issues, and I don't know what happened, but all I heard was screaming. I keep
Okay. What are you upstairs getting for your mom right now?
My mom said to get her phone.
Her phone, okay. When you get back down there, is there a way I can talk to her?
I don't know, she didn't make
You want to talk about fetching everybody permit to 679 Main Street, Benefield, so 1645. Someone on it, agent unresponsive, unauthoritative. Can I talk to your mother, please? Can I talk? Hello? The police are there?
Yes.
Okay, I'm gonna let you go and talk to them, okay?
Okay.
You're welcome.
Jurors, I think we're going to take our morning break right now. We will be going and hearing the evidence until 1 o'clock, but I'll give you a short bathroom break so that you can attend to those needs, and we'll be back here at about 12. All right, so keep it as efficient as you can.
Good. I'll rise for the jurors and place your notebooks in the chair. Exit this way.
I try to keep it to a short break. I would like to start back up at 5 past the hour.
Thank you.
All right.
arrest, your reentry. This court's now in session. Be seated, please.
You may proceed. Thank you. Hi, Sophia. I apologize that you had to hear the 911 call. I'm just going to ask you a couple of questions about it, if that's okay.
Okay.
With regard to that call, there was a point in time where you were saying things to the 911 operator, and I'm just trying to find out if you recall if you were saying he was bleeding or breathing. Do you know?
Breathing.
Breathing? Okay. Did you see any blood on your father?
No, I did not.
Okay. Did you see any blood on your mother?
No, I did not.
And I know you indicated you didn't see any injuries on your father. What, if any, injuries did you see on your mother? Anything?
No, I did not see any injuries.
And at some point in the course of your phone call, I believe they had asked to speak to your mother. Do you remember that?
Yes, I do.
And could you explain, just because it was hard to hear with all the background noise, where was your mother that she couldn't go on the phone?
She was just crying.
Overruled.
She was what?
Where was she? Where was she? Where was your mother?
She was near my dad. She was sitting right next to my dad.
Okay. And at some point, what, if anything, did your mom ask her to get for her?
Her phone.
And where was her phone?
Upstairs in her room.
And did you go upstairs and get her phone?
Yes, I did.
And was that while you were on the phone with 911?
Yes.
Okay. And with regard to the argument that you were hearing before your mom had you come downstairs, what, if anything, was different about that argument compared to other arguments? Did it seem different to you?
No, I did not.
And at some point after you hung up, or as you were getting off the phone with 911, did Marshfield police arrive?
Yes, they did.
And where did you go when they arrived?
I went out the side door to tell them to go in the side door.
Okay. And why did you tell them to go in the side door? Is that a easier route?
Yeah, it would be easier to get to my dad.
And did anyone go outside with you?
No, they did not.
And did you take them inside to where your father was?
Yes, I did.
At that point in time, had you learned why your father was on the ground?
No, I did not.
And once the police came inside the home, what happened next?
I don't remember.
Okay. Could you describe what, if any, observations you made about how your mom was acting?
She was just she was panicking.
Had you ever seen her have a panic attack before?
Yes, I have.
And what does that look like?
Just very shaky, crying, hard to breathe.
Is that how she was when you first came downstairs, or was that how she became when the police arrived?
That's how she was when I first came down.
And typically, you've observed this before happening with your mom?
Yes.
And how do you deal with that when you're there?
I just hold her and I comfort her.
And what, if anything, did you do to help her when the police were there with regard to her panic attack?
I grabbed her medication for her panic attacks.
And where is that?
Upstairs in her room.
And did you come back down? How soon after you gave her, is it a pill?
Yes.
How soon after did she calm down a bit?
If she knows.
That's an acceptable qualification. If you know, how long did it take your mother to calm down?
I don't remember how long I was outside after I gave her the medication.
So, okay, you gave her the medication and then you went outside?
Yes.
Okay. And sometime after you gave her the medication, did she calm down?
Yes.
So was she calmer when the police arrived? Actually, let me ask you this. In terms of timing, when did you give her the medication in relationship to when the police got there?
I gave her the medication when the police got there.
Okay. And typically, have you given her medication for a panic attack previously?
Yes.
And typically, how quickly does the medicine work?
If she knows.
If you know.
I do not know how long.
Does it take hours and hours, or is it?
I don't think it took hours and hours.
Okay. And once the police got there, did you speak to them briefly?
Yes, I did.
And then were you taken somewhere from your home?
I was taken outside.
And then at some point, did you leave your home?
Yes, I did.
And where did you go?
I went to the police station.
And was it there that you gave the recorded interview that you looked at the transcript from?
Yes.
Okay. And at some point, did you go to the hospital?
Yes.
And that's where your father was?
Yes.
And who was there?
It was just me at first, and then my brothers came.
And, okay. And at some point, you were given information about what had happened to your dad?
Yes.
Okay. Were you with your brothers when that happened?
Yes.
Okay. And drawing your attention to before you learned about your father's affair, were things different in your family back then?
Yes.
And in terms of your childhood, Sophia, can you describe what your parents' relationship was like when you were growing up before you learned about the affair?
There was no fight, and they were very close. They loved each other a lot.
Did they show a lot of love for you and your brothers?
Yes, they did.
Both of them?
Yeah, they always showed love.
And did you guys do family vacations?
Yes, we did.
Family dinners?
Yes.
And then after the summer of 2018, is that when things changed?
Yes.
And how did you learn about the affair?
They sat us down and told us.
And when you say they told us, who are you referring to?
Me and my brothers.
And after that conversation, did you see some changes in your mom's kind of behaviors?
Yes.
Your
And
Honor,
yes,
and we have an instruction with regard to the continual use of the leading,
I'm sorry, I missed that last.
of the leading questions with regard to this witness.
Right. I have noted some of the leading questions are to background things, but counsel, keep your questions neutral.
absolutely. What, if any, changes did you see in your mom's behavior?
What changes?
Yes, after the summer of 2018.
Just sad.
That was the only change you saw, or were there other changes as well?
No, it was more just sadness.
And was your mom a Zumba instructor?
Yes, she was.
Did she continue to do that after she learned of the affair?
Yes.
And you described her as being sad. Is that right?
Yes.
And did that continue, that sadness, up until your father's death?
Yes.
And other than sadness, you also previously indicated that there was fighting.
Objection, Your Honor.
I'll see you at the side of the bench.
A discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB texts, but they're not all the same. There's some of the same, and so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. It's what happened yesterday with Ms. Murphy. Those were items never turned over. May I approach? If you don't mind. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million?
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, There's never been a formal discovery filed by the defense, and the original witness lists were filed in the late June.
That, probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the, the defense
I can
has
enlighten Your
15
Honor.
days.
I
So,
can enlighten Your Honor if you
all right,
like.
please.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded, what we received in our discovery, among other things, was what we refer to as a phone dump, D-U-M-P. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, search it. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed. But at the deposition, I clearly presented these to Sergeant Keyless, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts. I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little,
I'm sorry,
please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to the point where there are things being offered for evidence that have never been provided to the state, that I can't even find the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem we're having. And the obligations are different, as Your Honor knows, and I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations were not fulfilled.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substantive statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. but I'm not gonna find that, there was a willful violation of the discovery rules, because it sounds like the defense provided, I haven't heard specifically, it may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached to his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone dump. We provided it to them. They listed it and said it's in our possession. So they did not provide us a phone
Okay,
dump.
so she already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing, and that also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent, I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so.
If we could just request that be done before we're in the middle of examining the witness.
And copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about, that being Defense Exhibit 3. And we had an objection. So, go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes, the court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes, okay, so we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Miss Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum, use of discovery depositions as substantive evidence in a criminal trial. I also had previously filed on July 10th of 2024 a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because of the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a Second District Court of Appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases, and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol, immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting a hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Could I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Yeah.
Would you mind? Please citation.
290 Southern 2nd, 73.
And I have one as well. I don't know if we want to hand it up now while we're reading.
This is what you just handed out?
Yes.
All right, I've reviewed Henry.
You want me to comment on Britain case that they just provided?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So we don't, I can't even speak to exactly what's in that, so I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overact, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britton case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charged, and the speculative nature of any real connection whatsoever as far as any apprehension in Britton's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call to testify a domestic violence expert. That domestic violence expert is going to educate the jury, in fact, he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along in the week prior to the shooting. Smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse, and you begin to develop a survival instinct for it. So that's why you employ the get along, go along, because you do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal was Ashley Benefield concerned about the release of the Broder report. Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal, by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify, I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions, some people call them spontaneous statements, and therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's a issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order, and this is, again, Smith, 606 Southern 2nd, 641, and this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing, 577 Southern 2nd, 682, and in that situation, the evidence was kept out, and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm, or not likely to do so. Finally, there was one other case in Hedges, which which is another case I think we've talked about, is 667 Southern Second 420. And this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence and unfortunately it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the court...
I guess you can ask, but I'm in the middle of a ruling.
Okay, well, I think it may be relevant, helpful for
Okay.
the court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay, so...
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt, and in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think the they're admissible at this point. So that's my ruling.
Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness that the rest of what was taken out be added back.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right, so I, just to put defense on notice that that may be an issue.
So we're going to bring the witness back in. And you can resume your cross.
So that the court doesn't run the jury in and out for naught. I've shown Suzanne the remaining aspect of my cross, anticipating there may be some objection to it. So,
And I would have an objection.
You do?
Yes.
Okay, can you step back out?
Sure.
Same rules.
Judge,
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, and maybe the defense can confirm, I believe these are supposed Google searches or internet searches for certain subjects
Yes.
that are on
yes,
Ms.
that are on
Benefield's
the phone,
and
that of which was extracted by this witness.
they are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry,
2020, Your Honor.
the first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, with a parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Doug Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming in.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Baroda's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, And then again on 5/11/20, ask Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project. And 6 tips on 5/11/20 to help you co-parent with an abusive ex. So, the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the predicate. Once the 9/11 tape came in, which said my husband attacked me and I shot him together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing
Hold on.
a murderous...
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now,
No,
at
that's-
this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
They're admitted. Now, I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. And I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response?
Judge, the reason this should not come in is the exact same reason that you just ruled on last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason now.
Could I please see the exhibit?
Of course. May I?
And the purpose of offering Defense Exhibit 4A is to prove that Ms. Benefield actually made those searches?
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone, and the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. You still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Keyless. I would like to make a proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read Defendant's Exhibit 2, or anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Keyless.
Judge, can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
But if we could just make a copy and enter it in.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages, Judge.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, got it. Yes. These are text from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer,
Correct.
right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that Detective Keelis would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would, Judge. I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes, sir.
Do you want Keelis to stay under subpoena? Because I want to give him the right instructions.
Yes.
All right, can you have Detective Keelis come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
different. Yeah.
That's why I did it phonetically.
Sergeant, I'm sorry. Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? I understand. All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. All right. Look, the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
Text message.
the What's Now apps, WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
4A is a composite.
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want,
Well, I'd like to have it on there because
Stip.
they showed it, but they
Yeah.
showed it very
Stip.
quickly.
Oh,
Defendant's Exhibit 5, which is
sorry, yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Thank you, Madam Clerk, for catching that.
Well, it's,
Right, 5 is in, 3 and 4 are proffers.
when you say, Your Honor, that Exhibit 5 is in, for purposes of proffer,
No, for evidence.
yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible, and,
No, I'm ruling 5 is admissible,
okay.
because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of,
Okay, but I think he hasn't, do you want it admitted?
But the witness is gone.
So maybe 5 should just be with the composite number 4 and not entered, just be at as a proffer.
all right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I just don't know what its status is then. All right. All right, say, you ready to call your next witness?
Yes, Judge.
Ready to bring the jury in? All right, let's bring him in.
And I think we are going to use I know we just opened the blinds, but.
All right, you all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything we talked about? All right. When we were last here, Detective Keelis had finished his testimony, and now we'll let the state call their next witness.
Stay with call Dr. Vega.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Thank you.
Hello, sir. I'm Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everybody.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here, so I manage the staff, I set policy, do procedures, and I do some of the casework myself, so I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, do you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And I'm gonna draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly, and I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case, of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you what's been pre-marked as states 86 through.
Can I see the photographs, please?
Yes, they're the same as the ones you just approved. When you just looked at them.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
Well, she's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches, or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge, just bear with me. Dr. Vega, we're going to try this one more time. I'm going to show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you. Your Honor, at this time I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment.
Okay.
And there's a pointer. Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest, there was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head, yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, let me plug in. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. And the chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been pre-marked as states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the, where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the, in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Thank you, sir. And where would the exit wound be?
Well, no exit, but.
I'm sorry, the projectile.
The projectile,
Yes, sir.
my mobility is a little limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal?
Yes,
Was it wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral,
His vertebral body.
thank you.
The
So
spine.
his spine.
Yes,
And would that injury have been immediately fatal?
probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes,
And how so? And this, for the record, states 91.
yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said, finally, you said he was also shot in the leg. Is that correct?
That's correct.
So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation-wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's, excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different,
And how so?
because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast-moving awl or punch, in that it goes in and it almost drills a hole into the skin, but when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically, the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf, and then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out, and that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Hard to see with
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
Thank you, Judge. So on me, the entrance was down here,
If it'd help, I can put my finger there.
and the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left, and from back to front. Yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I've made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you states 15. If you'll take a look at that and tell me if you recognize it.
Yes, I do.
And how do you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter states 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of states, this is states 97. Is that the same item that is in states 15?
Yes.
Thank you. Did you find any, I'm going to go back to the, well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
The absence reflects the same principle in either injury, and what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require, the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so, to be clear, you said the muzzle, so would that mean that if, it's not necessarily the body of the shooter, but if they had their arm extended, or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel for, and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated, because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And, Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell, when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And was there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also, there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Mr. Taylor Cross, and of course, the question is, do you need this?
I do not.
Yes, sir.
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice, thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct, yes.
Muscular build.
I don't think I used that terminology. I think I just talked about the weight and the body length.
I want to ask you, you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3-foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his
How loud if the witness has the knowledge to answer?
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
Objection calls for legal.
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because that's asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Vega.
State, any redirect?
Yes, Judge. Dr. Vega, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him, it entered through the side.
Yes, so the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running, or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, Doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena, you're free to go.
Thank you, Your Honor.
Judge, while we're switching, could the deputy pass 14 and 15? Would you mind?
Oh, pass, you mean,
Yes.
to the jury?
Sorry,
Wasn't
publish.
quite sure what you meant.
Sorry,
Publish.
I meant pass through the jury, yes, sir.
All right. Members of the jury, as with yesterday, we're to pass these around. These will go back with you during your deliberations. All right, state your next witness.
Daniel Hausdorff.
Madam Clerk, sorry, will you swear the witness in? Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Hello, sir.
How you doing, Judge?
My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
Hold on 1 second.
Oh, I'm sorry.
Go ahead. You all finish up. You're going to wait a second.
Yeah, I apologize, Judge.
I don't want anybody to feel rushed. But like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearms section.
And how long have you been in that position?
I have been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say well, we're going to get there, I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August of 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases from firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given the unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case. And everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory .45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials in my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
It's empty.
Oh, I was gonna say, there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorff,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fired cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it will go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Ron. Can we put it for a moment?
Of course.
Mr. Hausdorff, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7 which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLE case number, item number, and my initials and my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just so
Yes,
we can
ma'am.
talk about that part? You were
Yes.
really going. And so you said you first look at test to test, and can you explain slowly
Yes,
how, what you're looking for to compare those, to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10, and 14. Would you like to take a look at these items?
Yes. Thank you.
And tell me if they're items that you've previously seen in your lab.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight, and if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact, so I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in .45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing, the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
No, I think the first time you said fired in and then you said fired from.
The reason I just say in is that cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical?
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value for microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination, could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received 1 t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was unable to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is States 2. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
And I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
gunpowder. Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment? I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Mr. Houseworth, your testimony here today is basically that the ammunition was fired from that gun in this case,
Yes, sir.
and you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Redirect?
No, sir, thank you.
Can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena, you're free to go.
Thank you, Judge.
Thank you. State,
Your Honor, at this time, the state rests.
all right. Members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics we've heard anything about. And don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes. All right, you all can have a seat. All right, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm looking back through my notes. We've still got the issue of Vicky Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss? The expert.
Ferris.
Ferris.
Bruce Ferris, Your Honor.
I don't know where I got Bliss.
He's a police
You
officer.
smushed them together.
Okay. We've got that, and I have another Richardson issue. It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own,
To impeach.
her own explanation for them.
Yes.
Which would be inconsistent with the testimony Ms. Murphy gave.
Yep. And there's one other matter.
Oh, all right.
In an effort to protect Ms. Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday, so I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
by Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So, was gonna kind of give you all the option. If you wanna, I can give you the break that I'm giving them. You all can talk about, do we wanna do some more work tonight? How late do we wanna stay? Do we wanna get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when, when is Mr. Ferris gonna be available?
I would anticipate when we decide to call them, they'll be available.
Okay. All
I
right.
think we could do the JA, Your Honor, and the other stuff. Can we do the JA, and maybe if you want to do the discovery now? I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA, okay. I just wanted to clarify.
Sorry.
Thank you.
Well, yeah, I think let's at least get that done this evening.
Yes, sir. Yes, okay. That was gonna be, I was trying to figure out if you meant JOA or JA.
Yep, sorry.
So now-
That's the reason why breaking early would probably be good.
So, let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early, we've got stuff to do, and then we can hit the ground running tomorrow morning. Just so you know, because it's in, as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, a 33-day motion I'll have to hear first thing. If it hasn't been obviated by the filing of the information or a null pros, I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it, but you set it for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you. So
Yes, sir?
it's never easy, Your Honor. We have a witness issue. Faith Brown is available now, but she's not available tomorrow. She will not be a long witness. I wonder if the court would entertain, however Your Honor wants to do it, while we have the jury here, I can call her. Or case law even says the Supreme Court case of State v. Smith, the court could call her as a court witness. And when she's done, then we could do the JOA or we could do it in reverse.
I'm sorry, did you say she's here?
She may be outside now. She was on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't know about her.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly, based upon the case law, certain witnesses and facts and evidence are gonna have to be before,
Yeah.
not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state.
Well,
That's
and
the other subject of your
Yes, it
Richardson
is,
hearing.
actually.
Is those emails from the sealed hearing that we've now had access to, I think had to have been obtained by the defense from Ms. Faith, whatever.
Faith Brown.
Faith Brown, and, because the state's never gotten those until yesterday.
What was the date, September 30th of 20?
Judge, those emails came from the state.
You're gonna have to show me where, because
I don't
I
know.
looked in my entire.
Well, hold on, we don't need the back and forth. I'm trying to figure out,
I don't know how we have access to those emails.
listen, this is for me, who typically is just, let's start the trial, let's go. Let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be an outstanding idea, Judge.
My first one of the trial.
No, that really would work out pretty well, because I got witnesses like planes stacked, and my head is spinning over it. So, yeah, that would.
And just so you know, State, this is also, what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of hit reset, and then defense, you can, come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't, and maybe it was actual seated jurors, I can't remember.
No,
There were
it's,
conflicts that started next week.
But I don't know
I'm
if
not
it
sure what they were.
started Monday or Wednesday or.
I think the juror that, the gentleman we had last today, he has a conference starting Monday out of town. Not that we would be done tomorrow anyways, but.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
right, but does that mean finish Monday or finish Tuesday?
Oh, definitely
Define
don't.
finish.
Definitely don't finish Monday.
All right, so defense case done Monday. And
Then
then
we
you,
close Tuesday?
And then
Would
you-
that be the,
I think that might be optimistic. I think Wednesday probably is more realistic.
right, so finish defense case Monday, but then we have jury instructions.
right.
Oh, can't. I apologize,
That's
sir.
okay.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
Yes, I mean, you're correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, and I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
Right.
we'd be finished, try to finish the case up Tuesday, if not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I don't make the final decision, but that would be my opinion, is to not go a full day without doing any trial tomorrow, but.
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information was filed, so I do not have the hearing at 8:30. But we could start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock. And then we start the defense's case in chief around 1. And go as far as we can. Okay?
Okay.
You're nodding your heads, but I'm,
Yes, sorry.
Okay. All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with a goal of having them up here around 1 o'clock.
All right, so, I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
Over Monday.
Well, if she's not available tomorrow,
She's not. Is she available Monday? No, she's out the
I'd say maybe call her Monday.
Yeah, that'd be fine. I can
Mr.
do
Hill,
it.
she's not available
I
Monday.
just want to make sure she's available on Monday.
Sure.
Yeah.
Right, or, is she under subpoena?
No.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed, seems outrageous.
No, hold on.
Okay.
This is me, because I want to get these, I got a bunch of hearings that I got to get done,
Okay.
including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done. Did he step out to ask? What's he asking?
You want me to bring her in?
No, I just need to know, is that the plan?
Yeah.
So because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we could put her on today, then
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
okay. Can you give me a moment?
Of course.
to report, Your Honor, she will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
All right.
So, we're gonna do all the motions this afternoon?
Yeah,
Thank you, Judge.
yep. And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
I would, yes.
But while you're doing that,
Yeah.
can one of you stay?
Yes, I'll
And I'm
stay.
going to tell the jury 12:45
Yeah, you can
tomorrow?
let 'em go.
Well, no, wait a minute.
Right, now we could have them here in the morning.
Now I need them here in the morning.
Yes.
Okay, all right. I just want to make sure she's going to be available. Because you guys have every right and should be able to speak with her about her expected testimony. Did that come up during your conversations?
It didn't come up, but I'm sure she'll talk to them, Judge.
Go ahead.
Well, Your Honor, I feel like a vacation has been snatched away from me.
The what?
I feel like a vacation has been snatched away from me. I was picturing having tomorrow off. Jack. Is she out there? Okay. Judge. It's never easy. We have a small complication with Faith. It's an issue that Your Honor's going to have to deal with. She was not under subpoena by either side, and was not told that because she wasn't expecting to be witness, that she could not observe the proceedings. So she has watched some of the proceedings. Once I contacted her, told her that we needed her, we've told her to stop, and of course she's conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now, I'm just, you're on notice. We're just waiting for her, Ms. O'Donnell, to come back in and confirm that we can get, you guys can speak with her tonight or tomorrow. Yeah, just, I need to know that answer so then I can decide, I can let the jury go, because if you can't speak with her tonight, that'll be a whole other issue. Or depose her in the morning, one or the other. All right, Ms. O'Donnell is back. Is she gonna be available for you to speak with her this evening or tomorrow morning?
I spoke with her, we did not set up a time, but I think she will be available when I formulate when I need to speak with her again.
Okay, all right, great. So I'm gonna tell the jury to be here tomorrow morning, 8:45, start at 9. Okay.
Sorry, Judge, I didn't realize you needed me to come back.
No, it's fine, don't worry about it. Yes, bring him in. All right, y'all can have a seat. Welcome back, everybody. I know what you're thinking, that that was longer than 15 minutes. But, okay, so there are some things that we need to do on our end. And the reason I gave you that break was to have a conversation with the attorneys and kind of make a list of everything that we need to do before we can move on to the next step. So what I'm going to do is we're going to stay this evening and keep working, but I'm going to let you all go for the evening. So remember, please don't discuss amongst yourselves anything about the case or begin deliberations. Don't talk with anybody outside of the jury about the case. And please don't do any research on people, places, things, or legal topics you've heard anything about. Tomorrow, if I could have you downstairs in the jury assembly room at 8:45, and we're going to have a goal to start up here about 9 o'clock. I figure if we stay late, and then some things tomorrow morning, we should be ready to get going then, okay?
Yes, sir. Okay, thank you.
All right, thank you. Just fold up your notes and leave them right there on your chair. And we'll see you tomorrow. Okay, y'all can have a seat. All right, the state having rested, defense, your JOA.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 9/11. And 9/11, of course, is what you do to summon help. And there has been nothing indicated otherwise that Ms. Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is "he attacked me and I shot him." There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield, and if they are properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden. The self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintel, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this. 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where's there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State?
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind, regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there is also spite or evil intent. And that is disjunctive, so it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained, and she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time, and she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said that this was the same exact judge that she had not had luck with before. And implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side. So he was turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA.
Thank you. Mr. Taylor, would you like to place any rebuttal on the record?
Very briefly, thank you.
Or not briefly?
Yep, no, briefly. So here's what we have according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance as to what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed, and failed miserably, to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her, The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right, thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
Okay, all right, I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right, that the issue of self-defense can be established during the state's case in chief by a preponderance of the evidence. I don't find support in the law for that, and I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. You're going to see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the you're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it, I might be mixing apples and oranges. Something was 390 and something was 316. And
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing, and based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an
The
email.
auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. But the heading, forwarding it to her, was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list, and it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies, or at least clue me into where it is and what exact pages are intended to be entered, and that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that, I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
And do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified
But
something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation, that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at a trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, you know, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of the doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony, that can't be right either. So we have to find a happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. Well, I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Judge, yes, Judge, I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said, on page 4, I have an envelope to seal this, if necessary. I have Ms. Murphy's stand your ground testimony that I will pass to the court.
You might need to
Sorry.
slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking that was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at Stand Your Ground. So to now say he had no idea that she would do this, which the state finds it offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, was he turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about Vicky Mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Miss Murphy and Miss Brown as meaning different things? Could it be received by the jury to be substantial in their decision-making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was, documents. We could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently. But just at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about the fake Brown, because she was not listed as.
Yes, okay. Do you want to be heard on that?
Can we just have a minute? We were just
Of course.
discussing it. Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that, along with these emails, it feels a lot like sandbagging to the state, or trial by ambush, as I think your judge, as your honor called it. And that was our concern. But in the light most favorable, in our mind, to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed or they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
Now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed,
Yes.
I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing and calling of Ms. Brown.
Yes.
So hold off on, mechanic subpoena for now, the argument about it.
Yes,
Okay.
I
well,
think so.
I'm just gonna put that on the back burner for now. And-
I suspect that's gonna be resolved.
We still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on. I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
Skip that?
omit it respectfully.
Fair enough. No, let me look. I don't think it does. All right. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions they'll be asking. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions would be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs, you understand what you're doing, you're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended, I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart, and I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney, and this is just piling the pressure on the client. I'm sorry, Your Honor, I find it uncomfortable.
You wouldn't be heard for the right, I mean, it's my
I
decision.
would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm gonna tell you what I say, and if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me, so if you say, hey, don't answer that, okay. But I'm gonna have it on the record, because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify, my lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask, make sure that nobody's threatened you, forced you, or coerced you to make this decision, that nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do, so I'm glad I brought it up, that way you're aware of it, and if you decide not to answer any of those, that'll certainly be your prerogative, so. We'll have that, like I said, I want to let you know about it, and then we'll have that conversation either tomorrow or next week. All right, anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right, well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course, absolutely.
All right, Judge White, we're good. Request withdrawn.
Okay. All right. Anything else we can talk about today? No?
What time are we starting tomorrow? 9, she said 9.
Where'd my list go? Let's shoot for 8:45, just in case there's any last minute stuff.
Yes, sir.
And then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so.
Okay.
Right, we're gonna have them lined up one after another, ready to go?
Pretty much.
Okay. All right, we'll be off the record until tomorrow morning.